let me share my screen with you. So if you come to any of our previous ones, you will think, oh, well, you look a bit different to Catherine. Well, that's because Catherine's been double booked today, and she has been doing these now for quite a few months. And I said, look, I'll give you a day off. I'm only doing the one, mind. But yeah, I said I'll give you a day off and I'll do this one for you. So yeah, so normally you've had the lovely Catherine to take you through these sessions. So this one might be a bit different because I'm not sure how Catherine's done them all in the past. But yeah, just to introduce myself, anyone who hasn't met me, my name is Lindsay Gamester, an employment solicitor and one of the directors at Bhayani HR and Employment Law. And basically what we do is anything employment law, HR related. So you'll see a list there of all the wonderful things we can help you with. Of course, we've been very busy during COVID. We've been helping lots of businesses try and get themselves through. It's not all been doom and gloom. We've seen a lot of success stories. There's lots of businesses that have actually done really well, and we've been helping them grow and change how they do things so that they can continue to grow throughout. But sadly, yeah, there are some casualties, and one of the topics I'm actually going to be discussing today is redundancies. So just to give you a bit of an overview. So how can we help you? So if you don't already engage with our services, you may not know we operate what we call watertight HR and legal package, and we also offer health and safety services. So our watertight package is basically a one-stop shop for all your HR needs. It's a fixed monthly fee, unlimited advice. We offer template letters, handbooks, contracts. We can offer on-site support. So we can basically put together a package that suits you. If you are interested in that, or health and safety, any health and safety concerns, because obviously at the moment lots of businesses are looking at their health and safety requirements, then you'll see Jason is on with us. Jason, I don't know if you just want to jump in. I don't know if you can, just to introduce yourself. And as I said, you can make a free appointment with Jason, and he'll come and speak to you and just tell you what we do and how we can help you.
When you say it's free, it's coffee and biscuits, so technically it's not free.
Yeah.
But I'm happy to only accept coffee and biscuits as a charge. But yeah.
So yeah, so get in touch. Our lovely Jason can come and see you, and I said let you know how we can help you. So what we're going to cover today, well, you'll have all woke up to the news that now we're looking at possibly having some compulsory vaccines in place for certain sectors. So I've pushed that in this morning, last thing, because I thought actually this is a really important one. We're going to cover some of the latest COVID questions. So if you've been on our sessions before, you know, Kat likes to go through what we've been asked basically over the last few weeks, some of the weird and wonderful COVID questions that people phone up. Yeah, we've had some pearlers. But hopefully they'll answer some of your questions as well. We've also had a new case in the tribunal come out, so I'm going to cover that with you. We're only just starting to see the COVID cases filter through. The tribunals are very behind at the moment, but I suspect over the coming weeks there will be a few more. And then just to finish off, I'm just going to give you a whistle-stop tour of redundancies. Just in terms of questions, we want you to ask questions. If you go to the bottom of your screen, you'll see a chat feature. If you click on the chat, you can type your question in there, and we have Ellie with us today, who's one of our HR advisors. So she will be looking at your questions. If it's a quick one that she can answer, she'll type you a response, but it may be that she'll just save some to the end to go through with everyone. It all depends on what type of question, but please ask, please keep typing those questions in, because that's what we're here to help with today. So first things first, as I said, compulsory vaccines. We have had lots of calls saying, can my employer force me to have a vaccine? And our answer to this point is, well, no, not at this moment in time. Looks like that's about to change. At the moment, it's proposed for care homes. So none of this is set in stone yet, but it does look fairly imminent. So care home sectors now, they will be making it compulsory for their staff to have the vaccine. from the limited information that we've got available, we know that medically exempt staff won't be affected. So if you can't actually have the vaccine for various reasons, then provided that you can show evidence of that, then you won't be caught by this. We are, as I said, we don't know anything yet. This is all new. We know that they are thinking about rolling it out to other healthcare sectors, so NHS, but we don't know how far this is going to go. I suspect lots of companies are going to be jumping on the back of this now, going, well, we want all our staff vaccinated. We represent and advise lots of companies that provide services to others. And we have seen already there's been problems in certainly if you've got to go into people's houses, you're finding that the customers in the house are saying, well, we only want people coming in if they've been vaccinated, and that covers so many different sectors. So I do think this is going to start pushing out to other areas. We're still going to expect procedures to be followed. It's not going to be as simple as, or I don't know, Marjorie hasn't had the vaccine, just sack her. It's not going to be that easy. There's going to be, you're still going to have meetings, consultation, looking at alternative options, which might be things like home working, adapting duties so that there's less contact. It could be complete redeployment. The overall dismissal will fall under the category of some other substantial reason, which is, I say, it's a catch-all. So it's going to be quite broad, but I don't think this is just going to be a big free-for-all for people to get rid of any staff that refuse. So Paula, does this mean other sectors can also look at dismissal for staff who refuse to vaccinate? Not just yet. I think you need to hold your horses, but it's coming, I think. I reckon over the next few weeks, we'll see how far they want to roll it out into the other health sectors, and then I think you'll find that other areas will also be raising their hand and say, actually, this affects us as well, so we need our staff vaccinating. So it's certainly going to be a hot topic over the coming weeks. So we'll keep an eye on that one. Then we'll move on to our questions. So these are some of the ones that have popped up. So obviously changes that have happened over the last few weeks. We've seen the changes to the holiday list. So we've now got red, amber and green, where you can go, where you can't go. We've also unfortunately seen the extension until July. So we were all supposed to be free, so to speak, by the end of this month. It's not going to happen. I don't know about anyone else. I'm not that shocked. And I'm not... Everyone's like, oh my God, we were promised this. We weren't promised anything. So, yeah, that's not come as a massive shocker, but unfortunately, some of our clients have been affected. So hospitality, nightclubs, those clients of ours that were banking on restrictions coming off, even the restaurants who are running on such limited capacity, having to keep the numbers down. They were all banking on it being lifted. So yeah, so it's not to say that it's everyone's completely unaffected, but it's one of those things. We've got to get out of this in one piece. So yeah, so the questions then: if an employee goes on holiday to a country on the red or amber list, do I have to pay whilst they quarantine? Well, no, well, there are some people, unfortunately, that, for instance, was it Portugal the other week, they go off on the holidays, think they're in the green zone, come back, have to quarantine. It's not your responsibility as an employer, unless you have sent them there as part of their work duties. Then you don't have to pay them, but you should be considering other options. So remote working, offering the use of annual leave, unpaid leave. But to me, you should be having quite a clear policy in place so that everyone knows where they stand if they choose to go to one of these countries. You can't stop staff going on holiday and going abroad, but they do have to adhere to the government requirements and restrictions, and they need to then know how that's going to impact them at work. So just be clear with everyone. If you go into these countries, this is what we expect of you. This is what's going to happen. If my employee is working abroad in a country on either the amber or red list, do I have to pay for their day 2 and day 8 test kits on return to the UK? So obviously there is now testing as well as quarantining. again, if you are sending your employee there to work, then yes, I would be expecting you to pay. I think that would be very unreasonable if you refuse to pay. If they're just going on the holidays, then no, you don't have to pay. They might try and argue, well, it's in work's benefit that they have the test done to prove that they don't have COVID, but ultimately they're going to these countries knowing full well what the testing requirements are, and the burden is not on you as employers to meet the cost of those tests. So I had a holiday booked at the start of July, which I now cannot go on. Shock horror. This has probably happened to many of us now already. I want to cancel my holiday, but my employer is not letting me. What can I do? So we have seen so many employees who think that they have the right to pick and choose when they take the holidays. Certainly, there's been big arguments about whether when you're furloughed, is that a holiday? Is that relaxing? Should you be forced to take holiday whilst on furlough? We'll have covered that to death in previous presentations, but yes, as long as you follow the right procedures, you can force employees to take holidays whilst on furlough. But it's a similar situation where if someone has their holiday cancelled, you don't have to allow them to cancel their annual leave. They can't just say to you, oh, I can't go on holiday now, so I'm going to come into work instead. Lots of companies are keeping very close eye on their annual leave levels, because what many companies will end up with is lots of employees wanting to take their annual leave towards the end of the year when we've got restrictions lifted, and it's just not going to be feasible. Companies who are wanting to open up and increase their productivity, their opening hours, their staffing levels, won't be able to do that if all their employees are wanting to go on holiday at the same time. So no, you can refuse cancellations. You can still force employees to take pre-booked holidays, and with the right notice given, you can still force employees to take holidays full stop, whether they've got plans or not. Can I continue to work from home even after the restrictions have lifted, so that I have childcare over the summer holidays? This has been a common one. Working from home is not for childcare. I have a 3-year-old, so it's not that I'm not sympathetic, but I know that I would not be able to work and do my full job, answer the phone, reply to emails, give my job my full attention if I was also having to care for my child. Obviously, it does differ depending on the age of your children. If you've got kids who are older that can occupy themselves, then it may be different. But if the sole reason why your employees want to work from home is for childcare, then that is not an employer's duty to grant. And I do think they need to be looking very carefully at home working arrangements. So they can, of course, put in flexible working requests. One thing we've seen at the moment is companies trying to bring staff back into the office with mixed success. So you've got some companies where the staff are flocking to get back in because they're all fed up of being at home. But then you've got others where we're seeing a reluctance of employees to return because they've got quite comfortable into the new routines, work-life balance. Have conversations with people. I don't think it's the right approach to suddenly put blanket rules in place and you have to do this. I still think there needs to be some discussion. Whilst ever we've got COVID around to these levels, I still think you need to be taking people's personal circumstances into consideration. But if the whole issue is to do with childcare, well, pre-COVID, everyone had to sort childcare out for the kids over summer holidays, and that shouldn't change now. So the new case that we've had, so this was heard on the 6th of April. So like I say, it's very shiny new. It got released, I think, only yesterday. So we haven't had long to digest it, but I've had a read of the judgment, and what I've done is picked out some points. So I think this was heard in Watford. This case, it's a first instance case, which means that it's heard at the first tier of the tribunal, so not technically binding on other courts, but this to me shows that the judges are looking at this situation very carefully. I think they're being very sensible, And I think this is showing a pattern now of judges thinking along the same lines. So what happened? We've got an employee, so the claimant, who's the employee, sales and marketing coordinator in a business which provides PPE. So they were key workers from the start. So all these issues go right back to last March when when lockdown first hit us. And the claimant, so the employee, he didn't want to use public transport to travel to work. He thought it was too dangerous. The government then announced that coronavirus on the 14th Feb was a serious and imminent threat to public health. So at the time, you may not have thought much about this statement, but for employers, this had a big impact health and safety wise. So this triggered the requirements for risk assessments, but also possibly some enhanced protection for employees who were refusing to go into work. So the claimant wanted to work from home. He was told he couldn't. He was a key worker. His duties as well could not be done from home. So this wasn't, again, just a blanket ban of everyone must come in. He couldn't actually work from home even if he'd wanted to. Also, the company made the decision that the furlough scheme did not apply to them. They were key workers. They had ample work at the time because they were providing PPE. The furlough scheme was not appropriate for them to use for these circumstances. So the employer stated that those employees who did want to self-isolate, they were permitted to do so. So you could stop at home if you wanted, but you either had to use paid leave, such as holiday, or unpaid leave. So they weren't forcing people in. They did give them an option, but they weren't allowing the use of furlough, and they weren't saying, we're going to just pay you full stop for you to sit at home. I can imagine they probably had some different rules in place for those that were forced to self-isolate, but this person was not one of those. He didn't receive a letter from his GP. He didn't have a medical condition. His concerns were all to do with travel to and from work and the risk that coronavirus posed. So what he did was he repeatedly brought sick notes in stating he had coronavirus symptoms so he could keep activating isolation periods. His employer, rightly so, put him on sick pay, but they repeatedly refused to put him on furlough. He asked and asked and asked. So in the judgment, there's just reams of emails. And the final email was almost a threat that he made to them, indicating he wasn't prepared to work. In response to that email, they dismissed him with immediate effect. And they said a general ongoing failure on your part over a period of many months to support and comply fully with our company policies and guidelines. That was their reasoning. So basically, he'd refused to come into work. I think they probably did query the amount of sick notes that were coming in, were they genuine? And they just had enough. So what claim did he bring? He didn't have 2 years service, so he couldn't bring an unfair dismissal claim under the ordinary route. So what he relied upon was a health and safety exemption, which meant that if he could prove this, he would not need 2 years. And the section he relied on was Section 100 of the Employment Rights Act, which states that in circumstances of danger, which the employee reasonably believed to be serious and imminent, so take note of the word serious and imminent, we've heard them before by the government, he took or proposed to take appropriate steps to protect himself or other persons from the danger. So that's the claim he brought. And what he argued was me wanting to work from home and be paid to work from home. That was me trying to take steps to protect myself. You refused that. And on the back of my request to protect myself, essentially, you dismissed me. So the tribunal heard this. And spoiler alert, the outcome was they found that this was not an unfair dismissal. The employer had acted correctly. So let's just have a quick look at what they considered. So first of all, the judge did agree that there was a serious and imminent risk. The government had used them words themselves, so you can't deny that COVID is not serious and imminent. So that's already a tick in the box for the claimant there. He was prepared as well to accept that the claimant reasonably believed the danger to be serious and imminent. So there's two different things there. Was it serious? Did he believe it was serious? And he did. So the judge's like, fine, yeah, you did believe that, ticking the box for your claim. But then we have a differing opinion on what he meant in his final email. So the claimant said his email only showed a reluctance to work, not a refusal. The judge said, no, you refused to go into work. Your email clearly said you had no intention of returning. So that's, that's a score in the box for the employer there. The judge then looked at the employer's actions. So did they act reasonably? And the judge found that that they had acted reasonably in assessing whether he could work from home. And they were right. His job was not suitable for home working. And also the judge agreed that it was not appropriate to be using the furlough scheme in these circumstances. So then we're looking at the precise wording and the tests required under section 100. And the judge found that the claimant did not take or propose appropriate steps, in that he was not only wanting to work from home. So the appropriate step he would have taken was saying, I want to work from home. And it was agreed by all parties that that would have been an appropriate step. Well, he wanted to stay at home, sorry, not work from home. But his demands went further than that. He said he wanted to be placed on furlough or allowed to work at home so he continued to be paid. And he made a comment of, well, I need the money to cover my expenses. So the judge found that his demands for furlough and for working from home on full pay were not appropriate to protect himself from danger. He had the option of staying at home, either unpaid or on holidays. He could have done that. That was appropriate. If they'd have dismissed him because he chose to stay at home, unpaid, then potentially this would have been an unfair dismissal. But he didn't. He turned around and said, no, I want money. I want you to pay me to sit at home. So because he made those extra demands, the judge found that the tests were not met and his claim has failed. So moral of the story on this one, each claim is falling very specifically on its own facts. So you can't take this and suddenly apply it to every case of an employee being dismissed because they were unsure about coming into work. Key ones here are is it reasonable for you to want your employees to come in? Did you look at the furlough scheme and all other options? What's home? Why can't they work from home? But then also, what options did you give them to stay at home? So here, like I said, there was an option to stay at home unpaid or on annual leave. And the money side of it actually was irrelevant because this is supposed to be about imminent risk and health and safety. So a judge will look very carefully about how an employer has acted in this, but I think this is positive. To me, this really shows that they're thinking about it, and this is pretty much consistent with the approach we've seen by other judges in cases up to this point. So that was a good one. Right, and so we're going to take now just a whistle-stop tour through of redundancies. I think this is really relevant at the moment because we know we've got furlough until September, but I mean, I weren't even convinced it was going to be extended beyond what it was, but I really do think September is going to be the final straw on this, unless something drastically changes with the COVID levels, the vaccinations, the hospitalizations. Unless something really changes, then I think furlough will end in September. I can't see industries still being shut in September because I just don't think the economy can afford for that to happen. So we'll whiz through some redundancy points then. As I said, this is not a detailed overview. If you are planning on making redundancies, please come and talk to us. We've got redundancy plans we can guide you through. We can help you each step of the way. Just don't fall foul of any of the rules that we're about to discuss. So first things first, is it a genuine redundancy? So there's only actually that kind of three main situations that qualify for redundancy? Is it a closure of a business, a place of work, or is there a reduced requirement for employees to carry out a particular kind of work? You will note here, redundancy does not cover what we'd probably term as reorganisations. If your level of work is the same, but you've just decided that we could work more efficiently and less people can do the same amount of work, arguably that wouldn't be a redundancy. So we do need to think, are we going down the right lines in calling this redundancy, or should this be something else, such as an SOSR dismissal? That's some other substantial reason if it is a true reorganisation. So we can help you distinguish between those different situations. Then this is where the planning comes in. So we need to establish how many redundancies do we need. We need to look at the different areas that we require the redundancies in. So it might be that you have 5 people in accounts and you'll only need 2, but you'll have in your manufacturing, you'll have 10 people, you'll need all 10. So we're not making redundancies there. However, marketing, we're going to get rid of the whole department. So each department we need to look at separately, because we will pool people appropriately. So that's what we mean by the word pool and pooling decisions. So it's about deciding who's affected, why are they affected, and then how many staff we need to retain, so that we can then decide what the next step is. So we need to look at objective selection for criteria. Again, this is something that we can help you with. So that is basically how we're going to select people. Once we know this information, we can then decide whether we need to notify the Secretary of State. So if it's over 20, we've got to fill in what we call a HR1 form, and we have to declare on that form how many redundancies we're proposing, what steps we've taken up to that point, and that includes, have we nominated reps, which we'll come on to. So we need our plan fully in place before we can decide whether a notification needs to be sent to the Secretary of State. And you will note there as well, it says employees cannot be given notice of dismissal until the Secretary of State has been notified. So we can't get rid of anyone until we've done that form. So scoring then. So we now know how many people have got to go, and we know roughly who's going to be affected, but we need to do a fair scoring criteria to make sure that we are fairly selecting. For instance, as I said, you've got 5 people in accounts, you only want to keep 2. We can't just say, well, I really like Mary and John, had a fallout with Philip last week, and you know, Pete and Eileen, I'm not really that bothered about. You can't do it that way. Although reality probably dictates that you're going to get the outcome that you're wanting, depending on how we do your scoring criteria, we still need, it's on the face of it, it needs to look fair and objective. So we need to know how we're scoring, what we're going to use in order to narrow down those people. We need to be wary of discrimination. For example, if you're taking into account absences, then you need to be looking at, are any of those absences disability related? So your scoring as well, just points for good practice, is you have more than one person doing your scoring, so that, again, those personal views you may have don't filter into how you apply your scores. So, first meeting then, so this is your big one with everyone to explain. Unfortunately, we're having to make redundancies. This is why we're making it. Back in the day when all your workforce were in, you'd have a meeting in one of your larger workspaces. Now it's probably going to be Zoom, but really you should be trying to tell everyone in one go what's going to happen, and that's to avoid gossip and also people panicking if they're off that day. They don't want to feel like they've missed out on key information. So it's explaining why you're making the redundancies, how many, what we've done to date to avoid redundancies, and what we're going to continue to do to avoid redundancies. So that could be things like cutting down on agency staff. It could be maybe looking at temporary variations of contracts, for example, rearranging rotas, asking people to reduce hours temporarily. These are all things that we can do, or that may be appropriate, but we'd have to explore whether that's going to be the right option for your business. Ask your employees for their ideas, because they may come up with some good ideas as to ways that the redundancies can be avoided. Could be, for instance, they find that some of the processes are really inefficient, and that they've got better ways that they think that they can increase productivity that doesn't affect staffing, but obviously brings you in more money. Consider asking for volunteers for redundancy, so that this is normally a really good option. You ask people to put their hand up and say, yes, I'd like my figures. You then provide them with the figures that you're willing to offer. They then say yes or no as to whether they want to go ahead with that. You don't have to select people who volunteer. You can still be, as I said, selective in who you want to accept on your voluntary redundancy basis. Please be mindful, though, that there isn't really a legal basis for voluntary redundancy. Redundancy is a legal, fair reason for dismissal, provided that a procedure is followed. Voluntary redundancy skips out the procedure, so it's not technically compliant. So what we would be advising you to do for people who have accepted voluntary redundancy is to offer them a settlement agreement, so that you are fully protected and they can't turn around and say, well, I didn't realise that I was going to be dismissed, or actually I've changed my mind. Explain the pools and proposed selection criteria. So if you are applying selection criteria, then you need to tell everyone what that is and how it's going to be applied, when they're going to receive notification of scoring, for example. And also, if they are selected, they will have the right to take some time off to look for work. Make sure you note all your meetings down. So that's just your normal admin. Any meetings you have, keep notes of. Consultation. If you are making more than 20 redundant over a 90-day period, we also have a duty to collectively consult. This is alongside individual consultations. It is not just, it's not an either or, basically. You have to do both. It can delay things slightly, because you'll need to elect employee representatives if you don't already have trade unions in. The elections don't have to be elaborate, but they still need an employee rep present, and it's from that point that the employee rep is put in place that you can start your 30-day period. It's 45, I believe, if it's more than 99 redundancies. So you've got a 30-day consultation period for between 20 and 99. During that time, provided that you have reached an agreement with the reps as to what's going to happen and how it's going to happen, you can actually issue notices of redundancy, but what you can't do is dismiss anyone within that collective consultation period. So the individual consultation, so you've gone through, you've got your selection criteria in place, you've ticked the box for collective consultation if that applies, and now you need to meet with those people who unfortunately have been selected via your fair selection process. And you will have individual meetings with them. You'll obviously explain what's happened, why it's happened, but also give them the opportunity to review their scores and provide feedback. They also need to be given opportunities in terms of applying for other positions within the business, and also they may actually come to you with some very valid options to avoid their redundancy, which you are obliged to listen to. So these are supposed to be meaningful consultations. Sometimes employers say to me, well, it's pointless. We know that they're going to go. That you've still got to go through this process. You've still got to show willingness and show that it is fair. Again, make sure you take notes. Follow up on any suggestions. So yes, I'm telling you to ask, have you got any ideas to avoid redundancy? That's pointless if you're not going to do anything about what they suggest to you. You need to be seen to be acting on what they're proposing. So you need to be looking into what their options are. It might result in any scoring being changed. So it might mean that actually, once you've taken on board what they've said, you've rearranged scoring, they fall out of the pool for redundancy and someone else will move into it. So you have to start again. You have to then do your first meeting with that person instead. So it's, when it says repeating relevant parts, it's repeating it until we get to a point where it's fair. If your selection criteria has been fairly drafted, is robust, and has also been applied by multiple managers, you can avoid alterations to scoring by taking very careful steps. So it's not the case that anyone who challenges their scoring should automatically have it changed. If it's been, like I say, if it's been a well thought out procedure, there should be no changes. So we then have a final meeting with them where we provide them with feedback. We give them a further opportunity to make any representations or any other ideas. At that point, though, if we don't have any other alternatives, then we can declare that unfortunately they are going to be selected for redundancy. We go through the package with them and we remind them of the right to a time off. Obviously, these meetings as well, they're entitled to a trade union rep or work colleague. And then we confirm dismissal, and your dismissal letter is very important. It needs to be drafted thoroughly. It needs to cover all the steps that you've taken. So not only does it need to explain why the redundancies happened, which you might think, well, I've repeated that time and time again. Repeat it again, it doesn't hurt. So you'll explain why, and then also all the steps you have taken to save that person's position. And unfortunately, there's no alternative. They'll be made redundant. You can then confirm if they have a right to appeal. So redundancies generally don't attract an automatic right to appeal. We tend to recommend using an appeal process because it can weed out any unfair decisions. It gives people the opportunity to obviously question, and it might be that on reflection you look back and you think, oh wow, I got that wrong. This is your opportunity to undo it, basically. So we do tend to recommend appeals, and at the very least the appeal will give you a heads up about whether you might have a headache coming in the form of a tribunal. So the appeal itself is just the same. It's just a further meeting. You're listening to their representations as to why they think it's unfair. Obviously, if they just send you an appeal that says, well, I think it were unfair, I can't tell you why, I just don't agree with it, well, then there's not really going to be a lot more to discuss. You'll just be going over what's already been discussed and finding the same conclusion. So they need to bring something new to the table, and then you're following that up in writing. So that was our whistle-stop tour of redundancies. I'm not aware if we have any questions because I haven't actually had me come off. I'll have to.
No, we've had no questions at all, Lynn. Nothing.
No. Okay. So as I said, it was a very whistle-stop tour there. I appreciate I've done a lot of talking at you. Yeah, does anyone have any comments, or you can unmute, you can ask things. Is there anything you're unsure about? You've got us here if you've got any questions personally that you want to ask. No, everyone all right? Everyone's shaking their heads. So yeah, so that, I mean, that's probably a record. I mean, what is that, 40 minutes? I probably talked a bit fast. Kat's going to be like, what have you done to my COVID presentations? So, but as I said, please feel free to get in touch with us if you have anything further you want to ask or anything that I've said that you're not sure about. And yeah, look out for our newsletter as well, because we will be providing some further updates on the compulsory vaccinations as they unfold, and yeah, any other kind of relevant things that are happening. So yeah, if you're not already part of our newsletter, jump onto our website, sign up so that you can keep receiving those updates. So if there's not anything else, no other questions, then yeah, I will let you go, enjoy the sunshine, and yeah, get on with your days.